if we don't have the facts about those calls, what was discussed, are we in a position, at least as it relates to those calls, is the Commission in a position to make a determination that what was discussed in the calls creates a reasonable apprehension of bias? That's all I was putting to you. And maybe to reframe it, maybe can I ask you this? Do you accept that for a determination that the bias complaint, the feared bias is reasonable, for that determination, there has to be facts on which that determination is based? Facts must be put to the panel, and then the panel will say, yes, on these facts, we are satisfied, or we are not satisfied that the apprehension of bias is reasonable. Do you accept that as a proposition?
I'll accept it, Commissioner.
You accept that?
Yes.
Right. So on the back of that, I then ask the question, if we don't know what was discussed in the calls, insofar as it relates to the calls, limit it to the calls for now. If we do not know what was discussed in those calls, as you say, can you accept, should you not accept that the Commission is not, the panel is not in a position to say those telephone calls do create a reasonable apprehension of bias, because we don't know what was discussed according to you? Do you accept that we cannot make that determination?
If the Commissioner allows me to reply to that in two parts.
Yes.
On the first aspect, Commissioner, you are correct. In the absence of us knowing, or the Commission knowing, what was contained in those telephone calls, the Commission cannot rule on the apprehension of harm or of bias.
From the calls, yeah,
or
just
of
arising
bias,
from
yes,
the calls.
I apologize. But then there's two sides and two versions, if I may so put it, of what was contained or what was discussed. And based on those, and based on how the applicant perceives in his mind what the contents of these discussions are, then the Commission can be in a position to make a ruling as to whether or not there is an apprehension of bias. Now, Commissioner, I submit further that the issue here is not that Mr. Brown doesn't come back and give testimony in the Commission. The issue here is somebody else in the Commission may be elected if there's an election procedure, or appointed if there's an appointment procedure, to come on board and move with the cross-examination.
How much more time do you require, Ms. Mohmane?
On the submissions?
Yes. Your entire submissions. We started at 9:30. Now it is 6 minutes after 12 midday. If I was sitting in the court where I used to sit, we would have given you 30 minutes only. I'm listening. That doesn't mean I will accept the time that you...
Chair, I won't be longer than 5 minutes.
Thank you very much. Thank you.
Chair, lastly, I request to invite the Commission to the role of the evidence leaders. I believe I left it hanging, and I had said to the Commission that I will come back to it in due course. Now, to supplement what I had said previously, in a nutshell, evidence leaders are required to assist and facilitate the work of the Commission. And in doing so, they must investigate and marshal the presentation of evidence to the Commission. They bear the overall responsibility of leading evidence before the Commission, although it is subject to the direction of the chairperson. If I'm so permitted, may I direct the court to the matter or the ruling by Judge Nugent in the Commission of Inquiry into Tax Administration and Governance by the South African Revenue Service.
You don't need to read that. We have had sight of it. We have read it. Yes, yes, please continue. But of course, you may make whatever point you want to make about it.
Covers ground that we had included in the answering affidavit submitted to the Commission, including some of the legal submissions we made there. So I beg the Chair's indulgence if I come back and touch on the same issues that arose in the exchange, but I hope to give it a proper perspective in my address to you. And to begin with, Chair, let me just say that the evidence leaders oppose this application in the strongest terms. And obviously, we submit that the application should be dismissed, including some of the legal submissions we made there. So I beg the Chair's indulgence if I come back and touch on the same issues that arose in the exchange, but I hope to give it a proper perspective in my address to you. And to begin with, Chair, let me just say that the evidence leaders oppose this application in the strongest terms. And obviously, we submit that the application should be dismissed. And we do so on the basis that it's legally misconceived. And I have heard the shift in approach by my learned friend and the reference to Killian earlier, but I'll submit in due course that that there wasn't actually any shift in an argument and the legal basis, the wrong legal basis that was advanced. So it's legally misconceived. On the facts, it's not just unsustainable, it's a deliberate misrepresentation of the facts. And I propose to return to the facts in order to explain this. And it's an abuse of the Commission's process. Chair, I will address 4 issues. The first, the conceptual flaw. The second is the factual basis of the application. And I would like to have a particular focus on the altered WhatsApp record that was put forward by Mr. Mogotsi as a key part of the basis, the factual basis for his application. Third, the allegation of unfair questioning by Mr. Chaskelson. And finally, what we respectfully submit should be the appropriate ruling in the circumstances, including referrals for investigation for possible perjury, forgery, and contraventions of the Commissions Act and the regulations of this Commission. So the first difficulty, as I said, is conceptual. Mr. Mogotsi invokes the law of judicial recusal. He relies on Safu, on De Lacy, on Besson, on Burnett, and Mogotsi. All of those cases concern judicial officers or decision makers. None of them concern a commission of inquiry or even something akin to a commission of inquiry. And while my learned friend indicated reliance on Killian at the start of her submissions to the Commission, she continued to make submissions on the basis of a reasonable apprehension of bias, the test for judicial recusal. And that's not the test that applies, because Mr. Chastelson is not a decision maker. He doesn't decide credibility. He doesn't decide admissibility. He doesn't make any decisions about whether adverse findings should be made, when and how. Those powers belong to the Commission. What an evidence leader does, as correctly asserted by my learned friend, is an evidence leader assists the Commission. He leads, organizes, and tests evidence. That function must be performed fairly, but it's not adjudicative. It's an investigative function. To assist the Commission, we've provided the authorities that we think are more suited to an application of this sort, where an applicant is seeking to remove an evidence leader. And in this regard, Chair, we refer to the recent ruling of Justice Khampepe in the TRC Commission. And it was specifically an application that was made there too for the recusal of an evidence leader. And what she said is important. The chairperson rejected the proposition that the SAFU recusal test applies directly to evidence leaders. Her ruling held that evidence leaders are not decision makers. They function always subject to the direction of the Commission. The appropriate inquiry, therefore, by analogy perhaps with that of prosecutors, is whether the evidence leader's continued role would cause substantive unfairness in the work of the Commission. And that approach is consistent with the decisions in the two cases that we've referred to in the answering submissions, Porritt versus NDPP and DPP Western Cape versus Killian. In Porritt, the Supreme Court of Appeal rejected an attempt to equate prosecutors with judicial officers for the purposes of recusal. And in Killian, the same reasoning was applied. And in Killian, the issue there was whether the prosecutor should be removed because the prosecutor was the same person that had interrogated the applicant for recusal, had interrogated that person in an earlier statutory inquiry. And so there were serious concerns about whether there would be fairness on behalf of the prosecutor in that case, and the Supreme Court of Appeal rejected that argument. So the question is not whether the SAFU recusal test is satisfied, it's whether the continued involvement of the evidence leader would cause substantive unfairness in the Commission's work. Mr. Mogotsi has not shown that. Incidentally,
if the allegations made were true, would the test not be met? I'm not asking whether we should hold that they are. That's a debate we're still engaging in, and that's a finding we will make in the end. But if they were true, would they not meet the test?
Chair, the allegations are so serious. They go to the heart of ethics, professional ethics, and the integrity of the evidence leader. Those kind of allegations, if proven to be correct, would warrant a conclusion that there's unfairness. They are very, very serious allegations, and we take it very seriously. But of course, I'm about to...
It's something else whether
yes.
They are in fact true, and that's what you're going to deal with, and that's what we engage Ms. Mohomane on.
Indeed so, Chair.
Yes.
So, and that rests on the facts that
yes.
support this application.
Yes.
Chair, I actually wanted to say on the law, incidentally, in paragraph 40 of the submissions of the attorney for the Commission, Mr. Mukashwa, paragraph 40, it's pointed out that it's not just that the cases don't apply here because the test doesn't apply. There are quotations that are attributed to those cases which are not found in those cases. I just make it as an aside. For a moment, I thought whether I should even say anything about it, and then I rethought. And actually, it is important, because it is the responsibility of counsel who appear before any tribunal to ensure that the correct law and that is put to a decision maker. And whether or not the papers were settled by the legal representatives were very aware after reading our answering affidavit that that was a concern, but it's just not addressed at all. And I just wanted to make that point, because one needs to be able to rely on quotations as genuinely existing in the cases that I cited. I leave it at that. I don't want to take it any further. So much for the law and the cases, and the legal basis of Mr. Mogotsi's application. Let's turn to the facts. There are two main factual propositions.
Maybe before you do that, the other point that has been taken, and you didn't list it in the topics that you're going to be addressing, is the standing of the affidavit of the attorneys for the commission.
Yes.
And its consequence for Mr. Chaskalson's affidavit.
Yes, thank you, Commissioner. I think that the point is more about form than of substance. Mr. Chaskalson has submitted a full, detailed, comprehensive answering affidavit on oath. It is true that is annexed to Mr. Mogotsi's affidavit, but it's just a question of form, because Mr. Mogotsi sets out submissions, as you will recall. At the end of the last appearance of Mr. Mogotsi, the request was for submissions to be made by the applicant, and then for submissions to be made, including legal submissions, on behalf of the respondent. And it seemed to us, in the unusual circumstances of a commission inquiry, that this would be the appropriate form to submit it in. It's just a question of form. There's nothing that I think it's an entirely unreasonable allegation to make that there's no weight to be given to Mr. Chaskalson's affidavit, because it looks like an annexure and it's not a self-standing affidavit. His position is made very clear. He sets out the facts in his affidavit.
It says in the railway tracks answering affidavit.
And it does,
And
yes.
he says in paragraph 5, I am deposing to an affidavit, so it is an affidavit.
It's absolutely an affidavit, and moreover, he responds in that affidavit, paragraph by paragraph, to the founding affidavit of Mr. Mogotsi.
I think what I understood to be the issue that is raised about it is Mr. Mogotsi lacks locus standi to depose to an affidavit. That's the one part of it. And then the second is his affidavit, well, it's actually 3 points, as I think I understood them. It's the locus standi issue. And then 2, it is his affidavit contains hearsay, and then the annexure issue that Mr. Chaskalson effectively hasn't answered the allegations because his affidavit is attached as an annexure. So your exchange now with Commissioner Khumalo deals with the third part, which is, well, there is an affidavit that is before us, but the antecedent questions is locus standi, and then the second, I said it was?
Hearsay.
Hearsay. Thank you.
Well, if one reads the affidavit closely, there isn't hearsay. What one will find in the affidavit is reliance on Mr. Chaskalson's own affidavit for any factual proposition that relates to the communications between Mr. Chaskalson and Mr. Mogotsi. It's a repeated referral to Mr. Chaskalson's affidavit. And where it goes beyond Mr. Chaskalson's affidavit, it does so with reference to the record, transcripts of this commission's hearing.
If we accepted that parts of that affidavit, Mr. Mogotsi's affidavit, contains hearsay, can we disregard that hearsay part of evidence and yet still end up with an affidavit that deals with the other issues that are not an answer to the facts of the exchanges between the two?
Commissioner Beloy, I have two responses to it. The first is, these are different proceedings to a court of law. How you assess the probity of that evidence is up to the commissioners. But hearsay evidence, as we know, is admissible in a commission of inquiry. That's the first thing I'll say. But let me say this too.
Does that not apply to the evidence of witnesses to the commission?
To the extent that Mr.
lower standard of how you treat evidence.
To the extent that Mr. Mogotsi is a witness here in providing this affidavit, then the same would apply. But even if you were to disregard what you may consider to be hearsay, and I'll say again, I'll repeat again to the Commission, there's very little hearsay if any, in that affidavit. But even if there were, and you were to disregard it, the strength of this opposition doesn't rely on Mr. Mogotsi's affidavit. The strength of the opposition relies on Mr. Chaskelson's affidavit.
Is it open to us, to the Commission, to say can we do this? It's a question. We say these paragraphs contain hearsay evidence, which is what is contained in Mr. Chaskelson's testimony anyway, as you say, affidavit. So we disregard Mogotsi to the extent that those parts, because to say it contains hearsay evidence, as I understand the position to be, doesn't mean we necessarily reject the whole affidavit, right? You look at what, in fact, in the affidavit is hearsay, and then you decide how to treat it.
Mm-hmm.
Could we retain Mr. Mogotsi's affidavit on the basis that it places Mr. Chaskelson's evidence before us? I don't know if you understand what I'm saying. His affidavit before us, even if we disregarded the parts that we ultimately say this is hearsay evidence. I don't know if I'm articulating.
I think I understand what you're saying, Commissioner Beloy. I see no reason why you can't do that, even if you were to disregard large parts. And remember that that affidavit doesn't just deal with the facts, it also is here to make submissions. And to make submissions for the purposes of assisting the Commission, which is why we put to the Commission case law that is intended to set the correct legal framework for this. The approach is not to say, well, the applicants didn't make out a case, there's no legal foundation, full stop, which is what one would do in a normal case. You may not necessarily go down a long road. You'll say there's just no case that's been met here. We're in a different position. We're here to assist the Commission and to put all evidence and all law that may assist the Commissioners in making this decision. And that's the value of that affidavit of Mr. Mogotsi.
And the complaint or assertion that he lacks locus standi, it's accepted that he acts by the applicant, that he acts for the institution. And so I understand the applicant to accept that he has standing to speak on behalf of the Commission, and yet there is a submission that he lacks locus standi. I'm not sure I understand how there's an acceptance and yet that kind of complaint. Do you want to say anything about it?
Commissioner Beloy, I have to